Hello everyone and good morning. I'm Jane Hanlon, the Mortgage Club Manager, and today's session of Ask Jane. Joining me today is Peter Barton from Ashfords Solicitors, and the question that we've had put to us is information about lasting power of attorneys, and in particular, what is it? So over to Peter, please, if you could explain as a solicitor, lasting power of attorneys to our members.
Thank you, Jane. Hi, everybody. Gosh, we'll be here for hours, Jane, on this one. So there are a number. Literally, this is an all-day topic. So a number of different types of lasting powers of attorney. I'll start. There are three different types. So there's first of all what's called a general power of attorney, and if anyone's producing one of those to you to proceed with an equity release case, it must be discarded. A general power of attorney is one which authorises somebody to sign on their behalf in relation to anything, property, finances, but a general power of attorney is only valid whilst you have your mental capacity. You generally see those. So for example, Jane, if you were selling your house and you were going to be away for a month and you were conscious that contracts had to be signed off whilst you're away, we normally give a general power of attorney to a friend or family member or to the solicitor for them to sign off for you. Now, and the minute you're back from holiday, they have an expiry life, and the minute you come back, they're torn up and job done. So, if you ever come across a general power of attorney, anybody, it just can't be used for equity release. None of the lenders, solicitors will accept it.
Okay.
We normally see. Now, those of us that have been in the market a little bit longer, Jane, you will know what I'm talking about. There are two types of power of attorney at the moment. There's enduring power of attorney and a lasting power of attorney. The enduring power of attorney, after the 30th of September 2007, you can no longer make them, but don't worry. If somebody shows you an enduring power of attorney and it's all been completed, then it's all fine. Just because it's old doesn't mean that it's broken or doesn't work properly. It's my adage. Both documents, enduring and lasting power of attorney, do the same. They are authorising somebody to look after your finances when you're physically able to do it yourself or mentally unable to do it yourself. With the enduring power of attorney, it can be used before you've lost your mental capacity, and it doesn't have to be registered at the Court of Protection. But of course, when we're talking equity release, the lender's solicitors will only entertain a power of attorney, a lasting power of attorney, or an enduring power of attorney case where the person has actually lost mental capacity. I think that's important here today, is if you're seeing somebody in the family that are saying, oh no, mum panics when she gets an official letter, as my mother used to, we'll do this via the power of attorney. You can't. If the borrower is able to sign it, they have the mental wherewithal, yes, we can deal with the family, to take ease some of the pain from them, but it must be signed by the borrower. So it's only loss of mental capacity. The enduring power of attorney, to be validly used in an equity release case, needs to bear the stamp, and it is just such a stamp on each page from the Court of Protection. If you're meeting with somebody and it doesn't bear that stamp, but it is a good document, they can just send it off. And unlike the lasting power of attorney regime, the enduring power of attorney regime, I'm pleased to report, there was a 1-month statutory period in which it has to be registered within. So we're not talking about 6 months as we are with a lasting power of attorney, or how long is a piece of string. You know that after 5 weeks it will come back stamped. They can proceed with the equity release case. Lasting powers are somewhat different. They can only be used if you've had it registered, and again, it's conferring that authority on somebody to sign on your behalf. Now, the thing that I would forgot to mention is under enduring powers of attorney that you need to watch out is that certainly you need to watch out who has been appointed under the lasting power of attorney. So if, Jane, for example, you had your other half appointed under the document, and you're both doing a joint plan together, then that just won't work, because one person can't sign off for both of you, so you need to appoint somebody else. So whilst both documents confer the same powers, both have to be registered. You need to watch out who has actually been appointed. Ideally, Jane, it would have your other half and then other family members or other people appointed, so that there's somebody separate who can sign off for you. So lasting powers of attorney and enduring powers of attorney are really conferring on that person the ability to sign off your finances for you. So you're seeing somebody who's lost mental capacity, the family can step in and sign. You just need to, and I'd always say, run the documents past us. If you've got documents, you want to check that A, they've been done properly, and B, they appoint the right people, then you can send them through to us. You also need to watch out within the documents, both documents, there are sections whereby you can put restrictions on. So we need to check to make sure that there's nothing that says, I wouldn't approve an equity release scheme going ahead, or, for certain transactions, X needs to be notified. So I certainly, and also as an advisor dealing with a lasting power of attorney or an enduring power of attorney, you're dealing with the attorneys. If there are 2 or 3 appointed, check what the appointment is. There are 2 types of appointment. There's a joint appointment or a joint several appointment. A joint appointment means if you are appointed jointly, you would both have to sign the documentation. So even if I was abroad, I'd have to sign it. And if it's a joint and several, it means that, yes, I can still be kept informed, but Jane, you can just go ahead and sign it by yourself.
So do you have to do money laundering on the attorneys then, as well as the borrower?
Yes, we do. So in the same way that you ask the borrower for address identification and passport and driving license, we'd have to do the same on the attorneys. And certainly, if the end of the point goes, if there are 2 or 3, whilst the financial advisors are advising all the attorneys, we would be doing the same. So we'd be corresponding with all of the attorneys. So if you're seeing somebody, I have come across this situation, you're seeing somebody, it's one of the attorneys, but say, well, my sister's the other attorney, but she doesn't like this. We then have a problem because they will have to be informed and have to consent to it.
Okay, so I mean, to me, it seems quite important to have a lasting power of attorney for this sort of age group of people in the sort of later life borrowing arena. Would you go with that?
I couldn't agree more. And certainly, if we're seeing people now, and I would say I'd rather be making a power of attorney for you now, whilst we can joke about you, losing your marbles, as it were, than having to visit and get one signed up. So I would also, and certainly I've spoken with many of your advisors on advice. Say, well, when you're entering into a equity release, why don't you have somebody who can do a lasting power of attorney business for you? Because certainly within our letters, we're saying, dear Jane, we're all giving you a head now, you really ought to think about a power of attorney, especially when there's a drawdown attached to the plan. Because Jane, you're fitting well now, but 10 years down the line when you come to get some drawdown, if you can't sign for yourself, who's going to do it for you? So that's where the attorney comes in. So I think almost as a marketing tip from the session I present to people, but if you're the advisor, you're seeing the client, you've actually got all the information more or less that you need to draft the lasting power of attorney for the client. So the only additional detail you need is who do you want to appoint. Now, with no disrespect to anybody at all who drafts that lasting power of attorney, it is very much a box filling, tab through the document and fill it into name, title, address, who you're appointing. So it's quite a straightforward process. So actually, if you have a very good power planner or administrator in the office, it's certainly something that you could create as a business as an add-on to the equity release, because it goes hand in hand. When you're having those conversations, you're saying, Jane, you're saying to me, I don't need this money now, but I might do in 5 or 10 years' time. That's the perfect in to say, actually, Jane, just in case you're not very well, how about appointing, but don't appoint a partner, appoint somebody else.
That's a very good point. So, I mean, is it very expensive to actually register them?
Well, interestingly, certainly anybody can go online and download the forms. The registration fee used to be horrendous. It's now less than £80. I think last time I looked at it, it's £63 to register one. So obviously 126 for a couple.
Yep.
If the person is in receipt of means assessed benefits, like the old income support sort of thing, then they waive the fee. So if you're seeing people on, who actually have very low income and no benefits, then there's no registration fee. But certainly, as a financial advisor in the company, I would be saying to you, and I give training to financial advisors on how to draft the documents and what, how to draft an attendance note, what you should be looking for to note down, really to protect yourselves and the family.
Excellent. And I mean, in the current climate, I mean, we don't know, but are they taking very long to register now? Because I would imagine that that's a bottleneck at the moment.
You're right. You're spot on as ever, Jane. It's one of those, you know, certainly with the enduring powers of attorney, you can guarantee you'll have it back within five weeks of submission. Lasting powers of attorney are you're looking at 3 months. So,
Right.
so if you're seeing somebody today talking about equity release, and we know the conversations can take a few months in the same while it'll be via lasting powers of attorney, I'd be saying to the person, work, you know, make sure it's registered. If it's not, get an application off now, because hopefully by the time we get there, the lasting power of attorney will be ready. One important thing that people listening to this need to know is that where a case is proceeding under a lasting power of attorney, you know, either solicitor will need to be holding the original document, not a photocopy signed off by the solicitors, but the original. This isn't me being difficult. I know I have my moments, Jane.
Right.
This is a requirement of the lenders and the lenders' solicitors. We, the solicitors, have to give a legal promise to the likes of Evershed and Act, Optima, Berry Smith, saying, yes, I promise you that I'm holding the original in my possession until the charge has been registered at the land registry in favour of Pure or whoever.
Right. So I mean, registering them in charge now there's delays there as well, isn't there? So the borrowers or family who are acting obviously need to prepare for that, don't they? The delay in getting the original documents back.
They do. We can always let them have certified copies. You know, certified
Right.
that is as good as the original. And you might say to me, Peter, on the other, but why can't you just hold a certified copy? And I'll say that's because of the lender's requirements. And it all goes back to actually not the lenders being difficult, but it goes back to the land registry, because at any time, if they're not, so when it comes to register the charge, if they're not happy with the copy that has been supplied to them, they can insist on seeing the original. And the lenders quite rightly take the view, actually, it's far easier to get it from Peter, who's holding it, than to go back to the clients who've got their money, and we might not hear from them again. So I do take their view. But, and certainly, we don't send the original anywhere, we just hold on to it in storage. And
Right.
we get the charge back, we release it, we then release from our undertaking, we send it to the clients by special next day delivery.
Fair enough. That sounds good. Well, we've got a few questions that have been put to us by our members. So if I can ask you a few and hopefully get a better understanding.
Hopefully I can answer them, Jane.
Yeah. Right. Can an LPA transfer money to themselves? Because we get instances at the desk where, for whatever reason, they're owed money and they're waiting for the LPA to come through the courts. So can they actually pay themselves back?
Oh, this is a good question. Now, it goes back to what are the purposes of the equity release. Now, under the rules of the Office of the Public Guardian, who regulate lasting powers of attorney, monies can only be used on an equity release if it benefits the person that is incapacitated. So, you know, if the idea was, you know, if you're seeing an attorney and saying, oh, well, you know, we know that mum and dad would have given us this money, so can we do it under the power of attorney so we can pay for our own mortgage? You can't, unfortunately, you can't do that unless there has been a historic, regular pattern of gifting by parents, and it's, you know, for example, paying the school fees once a year. That can continue under a registered lasting power of attorney because there was that previous pattern. But if there's been nothing before, and you know, and even if it's done to save inheritance tax, for example, you know, if there's going to be any gifting at all made, you know, the lenders will either decline it or they'll say produce a court order from the Office of the Public Guardian confirming that, you know, that they're happy that money be given to the attorney or gifted away elsewhere. And believe me, Jane, having done a number myself for extremely wealthy clients, and we're only talking gifting the annual inheritance tax allowance of £3,000, they're very reluctant to release any funds by way of gifts. And that also impacts as well if, for example, you've got an incapacitated person borrowing funds to improve their home. If the attorney, for example, the child, is living in the property with the incapacitated person, that will also be declined because they're saying, the lenders will say, somebody other than the incapacitated person is benefiting from those home improvements. So the purposes of the loan must be to pay off mortgages, debts, or care, you know, for home improvements if they're living there by themselves or with their other half, that sort of thing. So gifting is a big no-no unless they get a court order, which, you know, I would put the shut of time that they won't get.
So do you as solicitors actually ask for the purpose when you actually do the face-to-face visit?
We do, and we ask for it in writing as well.
Oh, right.
Yeah, we do, because we have to give undertakings to Evershares and adults to very strict that the purpose, that the purposes of the loan are for the benefit of the incapacitated person.
So what would happen if you've got a joint application where obviously some of the funds perhaps were being used for care, and part of the funds perhaps were to do some sort of essential repairs on the property for the other person residing within it?
Well, because the incapacitated person, if they're in a care home, you're still enhancing the value of their asset, which is the property, and actually it's their property, so that's not a problem. And so they can either be deemed to be the other half's share that's being used.
Yeah.
Because we're enhancing the value of the property, it's not a problem.
Another question. Can the LPA sell the home to pay for care fees?
Yes, they can. Certainly, they have. And one thing I didn't mention earlier, and apologies, listeners. There are two types of lasting power of attorney. The financial one gives them, unless the incapacitated person, when they made it, put in restrictions, they have basically a clean slate as to what they can do. So, Jane, for example, they could sell your home, they could invest money in shares if it was sensible, they could close bank accounts, open bank accounts. As long as it's in your best interest, they can do anything. The second type of lasting power of attorney, which people will have heard of, is the health and welfare. That's to do with finances. It is purely to do with consent to treatment in hospitals, choice of care homes, that sort of issue.
Thank you. What happens then if you've got no lasting power of attorney, but you've actually lost capacity? We hear this a lot at the desk.
Yes, you probably heard me sigh then, Jane, in desperation. Yes, we have to get the family back in the position they would have been in had a power of attorney made, and that's called a deputyship order. And it's a very lengthy process. It's a minimum 6-month process, over 80 pages of forms to complete, and it's very expensive. You're looking at considerable amount of money being used. It's usually about £800 within fees to the OPG for that, and you really you end up with a court order from the Office of Public Guardian saying, we hereby authorise Peter Barton to be the deputy for Jane Hanlon, and we give her the following powers. Now, that's the first stage, and that would put them back into almost the position of the lasting power of attorney. But aside from that, if they're doing a choice, they have to apply for a second order that specifically authorises an equity release case. So this is a tricky one this is where I particularly feel for advisors, because obviously being a 6 to 9 month process, the second order has to stipulate, it says, I hereby authorise Peter Barton to take out an equity release scheme with Pure for the sum of £80,000 with a reserve, for example, of £40,000. It has to be that detailed. You can't just say, I hereby authorise Peter Barton to take an equity release scheme on behalf of Jane Hanlon. So you imagine the poor advisor back in January seeing Jane, or Jane's family rather, and saying, right, you need to do this, but when you're submitting your application to the OPG, you need to be saying what lender we're choosing and what amount. And it'll be 9 months' time. So, of course, one particular lender may have the best rate in January, but come through to September, when we get the order back, it might not be. So it's one of those that you can say to counsel, look, I can give you the best rate today, but it may have changed because of time, because obviously in September the family didn't say, well, I don't want to go with X. Then you're going to have to do a whole new application for a further court order.
Well, that just highlights really the need for a lasting power of attorney, doesn't it, right at the initial?
It does, and if I was going to be listening to this, I'd be speaking with my administrator and getting them onto doing lasting power of attorney business.
Yeah. It's, another question was, can a person with dementia actually change their lasting power of attorney who they've nominated?
They can. It depends on the stage of dementia, and certainly their understanding. And certainly, that's why I always say to advisors, I say, well, You know, we're seeing somebody who's got early onset dementia, or they've got early stages Alzheimer's. You know, we take, you know, we would, if the client came into our office, or that's possible after tonight, then we'd be judging them on face value. So if we found, as long as they can, you know, as long as they can comply with the Mental Capacity Act, and understand the nature of what they're doing and who it impacts, they can change who they've appointed. And they don't necessarily have to make a whole, ideally you make a whole new lasting power of attorney, so you can revoke the old one and make a new one. But you can also apply just to take somebody off and put somebody on in their place.
Well, that's useful sometimes, isn't it, within families, because there can be
Well,
some falling
it's
back.
particularly useful, Jane, when for example, I'm sitting, you know, we're seeing an application where all that's been appointed is the husband or the wife, and obviously they can't sign on behalf of their jury, so we apply for an additional person to be appointed, rather than saying, well, actually the person's lost capacity, we're in a difficult position. It's far better than going down and quicker and cheaper than going down the deputyship route.
Well, that's a useful comment, actually, because again, we get that across the desk where we constantly see a wife or husband trying to sign for the other partner. So that could be another option for advisors to obviously discuss.
Yeah, it's like almost like an extra chapter to the lasting power of attorney. We're going to put some additional ones far quicker and far cheaper.
Great. Oh, that's very, very useful. So I think that mostly covers all of it, I think, doesn't it, Peter? It's quite a big subject.
I think the one thing I would say, Jane, is certainly, you know, from your panel solicitors' fees, that's us and Goldsmith Williams, GW Legal, we don't charge any, you know, it's still the 650 fee, even if it's going by a power of attorney. We don't charge extra.
Right.
If the power of attorney is going on. And we're both, you know, both Richard, Esther, and myself are both of the opinion that the case can go through just as quickly with the power of attorney as it can do with property and well. So please, anybody listening today, don't think it's going to take any longer, because it shouldn't do. Obviously, you know, unless you've got 2 or 3 attorneys signing all in different parts of the country, we can still get around that. It should be no slower, and it should be the same days. Okay, but that's all, you know, what I'm going to say on that, really.
No, it's lovely. Well, that's very good, I think, and very comprehensive about lasting powers of attorneys. And hopefully people will take note and get them ready in advance for if and when they should be needed. So thank you for joining me, Peter. It's been very, very useful. And just like to remind our members to keep putting their questions forward. We will have a session at the end of the legal series with all your individual questions that we will be answering. So please keep them coming. I'd like to remind everyone, for every care file you put through our platform, AdviseWise, we will now be entering you into a prize draw, and we will also be planting a tree. So thank you for your time. I hope you enjoyed.